Before we have David introduce himself, Alex, maybe a little bit about you in terms of the scope of legal practice that you do and things of that nature, and where you practice.
Sure, yeah. So I'm primarily a labor and employment attorney. So the firm that I work at, Delaney and Delaney, we primarily represent employees. So we're plaintiff side labor and employment lawyers. And I work a lot with physician non-competes specifically and with the broader area of restrictive covenants. So that would also include non-disparagement, non-solicitation clauses, confidentiality clauses, things like that.
I have to ask you, is there enough of that business that it's like a full-time job, or do you do something else? Can you do your entire practice just focus on that particular aspect?
I think you could. I don't. So I'm a little bit more varied, and I'm an associate at the firm. So generally I'm staffed on cases that one of the two partners of the firm bring in. But yeah, there is. I mean, frankly, you could focus almost entirely on physicians and restrictive covenants and likely have a 9 to 5, 5 days a week.
Yeah, that's amazing. And I've told you before we went on the air, I've always wanted to be a lawyer. I just wasn't smart enough. David, welcome to Healthcare Unfiltered. A little bit about you and where you practice and the scope of your practice.
Perfect. Yeah. Thank you so much for having me. I appreciate it. I was born and raised right outside Detroit, Michigan. I went to University of Michigan for my undergrad, so go blue. And then did my medical school in Erie, Pennsylvania. And then came back to Detroit to do my residency and fellowship. So I did a pediatric residency for 3 years, then did a pediatric critical care fellowship for 3 years after that. And then my wife took a job kind of southwest Michigan. So I was looking for a job close to her. So when I finished, I took the job at Fort Wayne. So I worked at Lutheran Health Network down in Fort Wayne for about 5 years until all this kind of came to a head.
So you're a hospital employee, basically.
I was employed by there's a medical group. So the medical group, Lutheran Medical Group, employs all the physicians at the hospital itself. So sort of not hospital employed, but like a group, like a lot of people are.
And was that your first job from fellowship?
Yep, that was my first job right out of fellowship. Yep.
So, Alex, I have to tell you, for all of us in the medical profession, when we take our first job, I mean, I don't want to speak for David, but we always feel there's very little we could negotiate. Like we're getting.
Absolutely.
Yeah. So do you review these initial employment contracts? And David, I don't know if you had your employment contract reviewed 5 years ago or not.
Yeah, actually, that's how I found Delaney and Delaney, is they were the ones. So when I took the job, it was my first time ever being to Fort Wayne, first time living in Indiana. And so I just basically Googled medical employment lawyers in Indiana, and they were the top rated one that came up. So that's actually how I found them initially and had them review my contract. And that was how our kind of relationship started. So actually,
before I ask Alex, what feedback did they give you when you first reviewed the contract? Did they provide comments on the contract? We're not talking finances. We're talking, other aspects.
Yeah. No, they were great. They basically looked through it, and I'm sure, as you know, and a lot of listeners know, a lot of days, especially hospital, these contracts are pretty standard. This is the contract that they give you, and a lot of it's non-negotiable. So we talked about things that are, big red flags that we really need to fight to get out of, things that are more like orange, yellow flags that not great, but, you kind of deal with it if you have to, and other things that are like, this is really good, keep this in. So they're very, very, very helpful for that.
Was the non-compete something that was discussed at the time 5 years ago?
Yeah, it was. And to my recollection, it was kind of a non-starter. This is the non-compete. This is how it is. Back about 5 years ago, there wasn't as much national conversation about non-competes. It was just something that was in every contract and something you dealt with. My wife had signed her contract the year before, and she had one that was very similar. So it was just kind of something that you just take it or leave it. And like you said, the first job out of fellowship, out of residency is important. You want to get a job, you trained all this time, and you want to find something that you think fits and is a good area. And so you might not get everything you want, but you try and get as much as you can that you want, and go from there.
And Alex, I mean, it's, first job from fellowship, most of us are looking forward to getting paid a little bit more for the efforts. And we really don't feel we could negotiate much. Like we don't feel, it's hard to negotiate against a hospital. I mean, we're one person. They'll say, okay, fine, we'll hire the next guy. It's not like they're really, unless you literally are super, super, super specialist. And, fresh of fellowship, you haven't had much to prove yourself yet. You may be it, but it just takes time. So how do you counsel your clients when you review these contracts? And maybe from there, take us into how you counsel them about non-compete.
Sure. So it's interesting that you say that. I think of all of the points in time where you can negotiate a contract with a hospital, your negotiating power is its highest as they're recruiting you, right? So that's the time to negotiate if you're going to try to change terms. I think that what you said is accurate. Negotiating power varies between subspecialties, so it depends on how in demand you are in the area. Clearly coming right out of fellowship, your negotiating power, even when it's at its zenith right there at the beginning, is still relatively limited. I think another variable is the size of the system, right? So if you're going into a very large system, it's much more of a take it or leave it situation. They don't want different physicians having different contract terms, particularly on things like restrictive covenants. Most hospitals that I have worked with or negotiated with, that's a sticking point for them. We don't want one physician in this group to have a different contract provision than all the other physicians in the group. So you make the ask, right? I mean, you always try to negotiate out of unfavorable contract terms, whether those are restrictives or whether that's something about how you're being paid or whatever. But the bargaining power is really more in the employer's hands at each step of the process. If you've got an employee who needs a job, particularly a physician fresh out of fellowship, I mean, you can walk away, right? But that's your choice. Either you take the contract with maybe slightly more favorable terms for having a lawyer help you negotiate it, or you go find a job somewhere else. And I think that's the problem.
Can you simplify to listeners and viewers restrictive covenant, just like without a lot of legalese, just like, fifth, sixth grader?
I think from a 30,000 foot view, a restrictive covenant is a contract provision that applies after you stop working somewhere. So there are three broad categories generally. A non-compete is obviously the focus today, but a non-compete is a restriction on performing similar services for a competitor within a certain geographical area for a certain period of time after you leave your current employer. Category two is a non-solicitation. So that can apply sort of in two sub areas. The first is non-solicitation of patients. So I think this comes up most commonly with smaller practice groups where you have, a patient relationship with particular patients. You have kind of a book of business, right? For a hospital doctor, that comes up a little bit less. You're sort of taking what comes in the door rather than maintaining a book of patient business. And then the other subsection of non-solicitation is employee. So, if a doctor leaves a hospital, the contract says you can't try to get your colleagues who you worked with at the hospital to follow you to the new place. You can't try to talk them into leaving our employment to go work somewhere else with you. And then the last is non-disclosure. So those are relatively common, not just for physicians, but across most industries where you can't disclose trade secrets or confidential business information, how they generate, for example, how they generate pricing on an estimate or something if you're in the construction business. I think with physicians, that comes up a little bit less in my experience. Generally, there's not as much sort of proprietary business information that they're concerned about. But for example, in the financial services industry, that would be your client list. Who are the clients that you work with?
Is non-compete like in other industries? Like, let's say I'm working for a law firm. I mean, let's say you're working for Delaney and Delaney right now. I mean, I'm just saying,
That's an interesting question. Yeah.
Are you able to walk out and work somewhere else? I mean, is it in finance, legal,
right,
like so many other sectors?
Yeah. I think they are common. So it's funny that you ask it that way. lawyer non-competes are generally not allowed. So that's
These
the only
lawyers,
industry.
I'm telling you, we knew it, right? We knew
We work
They know
the
what they're
system,
doing.
right?
They know what they're doing.
So, and I don't know if that's true outside of Indiana, but in Indiana, my understanding is that for most attorneys, non-competes are illegal, non-enforceable. But yeah, we see them in all different industries. Financial services is a common one. Executive level positions, obviously. So if you're the CEO of a big company, they would have a non-compete in your contract. I've seen nurse contracts with non-competes in them, RNs.
Okay.
But yeah, we see them
That's
across
helpful.
different industries.
So, David, then you saw the non-compete. I mean, it's one of those things where, frankly, you probably had a great interview. You like the practice. You like the hospital. It's not like you were thinking of leaving. I mean, did you try to say? Was it how many miles was it?
It's 50 miles.
50 miles. Did you?
50, yeah, 50. Yeah.
Well, I mean, did you try to say, can I lower it to 30, 20, 10? Like, did you try to say, okay, keep it, but can I, like, what did you try to do with it?
Yeah, so it was an interesting discussion for me because being in the pediatric ICU world, there's only a few pediatric ICUs. I can't go start my own pediatric ICU in the community. You have to be in a big enough city that can support a pediatric ICU. You need the other subspecialists to help you with it, cardiology, neurology, that kind of thing. So for where I looked in Fort Wayne, there's really only 2 pediatric ICUs. So in my assumption, and the reason they did it this way is because it blocked out the other hospital in the area. Because if I wanted to go work in Indianapolis or Chicago, up at Grand Rapids, Kalamazoo, those are all well outside of the range itself. So whether it was 50 miles, 100 miles, really even 150 miles, it didn't matter to me because there was no PICU within that radius. So whatever the radius they set, I think as long as it excluded their direct competitor, they were happy with it. So,
got it.
Yeah.
And you know, it's one of those things. Like I put myself. Let's say I'm hiring you, and you're coming and negotiating with me the non-compete. It's not easy. It's like almost you're negotiating prenuptial with your wife or significant other, right? And it's like, what are you planning? Like, why are you really? So, are there like, I mean, I don't know, like, how do you even negotiate that?
Yeah, my personal opinion on non-competes is complicated, but it's kind of, I mean, we're unfiltered. It's kind of a slap in the face. It's kind of, we're assuming you're going to leave at some point, so we're going to stop you. There's no belief that you're going to stay forever. So like I can say, I mean, I stayed for 5 years. I loved my job. I enjoyed it. I liked the people I worked with, the nurses, the techs, the docs. But like even before you start, they're automatically assuming you're going to leave and like trying to plan for it. It's just kind of like disheartening that that's the way that they see you. I mean, that's kind of how I felt about it. But it's just kind of a disheartening thing, but it's part of the job, I think.
So what happened that made you decide, just like better opportunity, you got bored with him? Like what got into that you made you decide that maybe I'd like to move on?
Yeah, so I mean, I wish I could say it was a better opportunity, but it certainly wasn't. I got bored. I loved my job. The hospital made the decision. They had 3 pediatric hospitalists that covered the pediatric floor, and then they had 4 pediatric intensivists that covered the pediatric ICU. And they made the decision to let the pediatric hospitalist go. And their decision was to have the pediatric intensivist then cover both the pediatric ICU and the pediatric inpatient floor at the same time. So my concern at the time was twofold. One, I felt like that was a lot of patients to take care of all at once. I mean, taking 2 jobs and making it into one. And second, my contract specifically said that I worked in the pediatric critical care unit. And so I was concerned, and I felt that to have me work outside of that was a breach of my contract. So that's kind of what started everything.
Alex, in negotiating non-compete, is the employee, like David, is he able to say in part of the negotiation, if you breach my contract, I'm out of my non-compete. If you fire me without cause, right, I'm out of my non-compete.
You can. So in Indiana, the law is that the party who breaches a contract first cannot enforce that contract against the other party. So the earlier breach in time basically stops enforcement of the contract. So because that's already the law in Indiana, you wouldn't need to negotiate for that. But statutory law, so the legislature in Indiana has addressed that. And there are now, very recently, certain situations where if a hospital, for example, lets a physician go without cause, the non-compete is not enforceable. But yeah, I mean, it's a negotiation. You can negotiate for whatever you want to try to get. There's no legal impediment to that. But I don't see physician employees negotiating for that now because the law is already favorable for them.
Just in the state of Indiana, to be clear.
That's my understanding, yes. Now, so I'm licensed in Indiana, so that's what I know the most about.
Right.
I know, for example, my understanding is that in California, non-competes are not enforceable for anyone. So it varies state to state.
Okay, but help us explain what that means by non-enforceable. So let's say I am in the state of California and I decide to leave, and then my employer sues me. I mean, the only way for me not to enforce the non-compete is to hire a lawyer to counter the lawsuit and to pay thousands of dollars. I mean, it's not, I mean, if they decide to enforce it, I can't just say, well, sorry, guys, you can't enforce it. I have to get a lot of, it's like a legal battle, right? And that legal battle could go on for months with a lot of money and so on, because even though it's not enforceable, the only way to not enforce it is in the court of law.
Right. You have to get a court to say that. I mean, at the end of the day, if they're going to sue you. Now, the general process that I see is that you'd get a cease and desist letter first. So you get a letter from your former employer that says, we know that you're working for a competitor within the restricted area, and we want you to stop doing that. And if you don't do that, then the next step is for your employer to file a lawsuit if they want to try to enforce the covenant. So it's a gamble, right? I mean, if you think that the non-compete is unenforceable, you can tell the employer that, but that doesn't stop them from going to court.
Yeah.
So you're right. They can, and it is a common tactic for an entity with deeper pockets than an individual physician to say, this is kind of a drop in the bucket for us. We can go to court and pay lawyers, and that doesn't hurt us as much. But yes, you still have to defend the lawsuit, and that does cost money.
You mentioned competitor a few times. Can you work for yourself, not a competitor? Can you just rent a place, lease a place, and open shop?
You would then be a competitor.
Oh, I see.
So competitor is generally defined broadly, and it depends on the contract. So the contracts have, in my experience, a definition of what competitive services are. So usually it's, the similar or the same services that you were providing for your employer. So yeah, I mean, if you've got a neurology practice and there's a neurologist working for a hospital and then they go open, a practice group down the street, they're a competitor. So no, I mean, assuming that the contract says neurology services are competitive, then you can't do that. So
David, this changed. They changed, obviously, your scope of responsibility. So when they informed you of this, what did you do?
So the first thing I did was, even at the meeting where they informed me, I asked specifically, do we need to look at the contract? Do we need to address the contract? And I addressed my concerns and was told, no, it should be fine. They gave a 90-day notice to the hospitalist, so we had about 3 months to figure it out. And throughout that 3 months, I was made to understand that they were going to help by giving us NPs or PAs or something to help us with the workload. And unfortunately, that kind of never really came to fruition. So when the time came to actually start this, my patient volume load went from an ICU, we had a 7 or 8 bed ICU to, 20, 25 patients in a day, which I personally felt was not sustainable. So went back to them and asked them about it again and kind of didn't get anywhere with it. So.
And obviously, I mean, from your standpoint, it's also about patient safety. It's not really, I mean, I think we're trained in residency and fellowship. We have put in a lot of hours, but you get to a point where if you're going to you can do it for a few days, but I appreciate you saying non-sustainable because you could make mistakes that could jeopardize someone's life.
Yeah,
So,
especially in the pediatric world, it's kind of different than a lot of other specialties in that it's very seasonally based. So any pediatricians out there will know the summers are slower and the winters are brutal because you get RSV and you get flu, and now we have COVID on top of it. So a light patient load in the summer doesn't mean it's going to stay that way. So this was October into November, so we were just kind of waiting for almost the other shoe to drop for RSV season to hit, and then all of a sudden the ICU becomes filled with intubated babies that get RSV, and then you get the floor with kids on oxygen and high flow. So it's not simple, straightforward cases. And my concern was that if you get an ICU full of intubated kids, those to me, the sickest kids take priority. So not only are you not giving the time you need to other patients, I was concerned that I wouldn't be able to get the attention. So you might have a kid on the floor who's not doing well, but if I'm stuck in a room having to intubate a baby or put a line in and can't get to another sick kid, I'm personally concerned that patient's not going to get the care that they need, and there could be something disastrous. So
and
definitely
this was
something I'm
2022,
very, very worried about.
2022 or 2023 we're talking?
This was about a year ago.
2022.
Yeah.
So you went back and you told them, hey, I can't keep doing this. And what happened?
So I talked to my attorneys, Delaney and Delaney, and said, look, I feel like this is a breach of my contract. And they said, we will file the paperwork. So my contract said if I felt like there was a breach, which I did, we have to give notice, and then they have 30 days to correct the breach. So we gave the 30-day notice, and in that 30 days, they felt that there wasn't a breach. They felt that they were still within the contract. And I disagreed. And so after the 30 days, I felt like the breach was still there and it was not reconciled. And so I walked away, as the contract said that was supposed to do. After 30 days without a resolution of the breach, the contract is over. So,
Alex, I mean, David felt there was a breach. You filed paperwork, you told them there's a breach. What was the response from the group or the hospital? They said, no, this was no breach. Like how did the conversation, why did they think there was no breach while you guys felt there was a breach? Where was the disconnect?
Yeah, I think it's just a disagreement on how to read the contract. So there are always, you can argue over what the words in the combination that they're in the contract mean, right? So I think it is a contract interpretation argument, where our argument is that the contract limits the work that Dr. Lankford was obligated to perform to the pediatric ICU and ICU sedation shifts. And their argument is that there's language in the contract that is broader than that. So that's the fundamental argument on the breach of contract claim. And the way the conversation happened. So what Dr. Lankford is describing is what's called a notice and cure provision, and they're very common in employment contracts, where either party can say, "You're breaching. You need to cure within 30 days, 60 days, whatever. And if you don't cure by the end of that period, then I have the option to terminate the contract." So the initial conversation was, we send a letter and we say, we think you're breaching, and this starts your 30-day clock. And their response to that was, we don't think we're breaching. So I think, when something goes to court, there's generally a sort of fundamental disagreement between the parties, and that was the fundamental disagreement here.
So is there an arbitrator usually? I mean, maybe I'm speaking out of term, but isn't you like when there's let's say two folks misinterpret this before it goes to court, is there arbitration where somebody can look at this and say X, Y, and Z?
There can be. So arbitration and then mediation is sort of the less formal version of that. Those are both alternative dispute resolution forums. So some contracts say you have to engage in arbitration or mediation. This one, to my memory, did not. So that's generally something that the parties would agree on and say, why don't we go to mediation and figure this out? Arbitration, in my experience, is more of a court substitute, where it's supposed to be a faster process, but it's very similar to being in regular court, where you have a neutral that's actually going to decide the issue. A mediation is a moderated negotiation where you have a third party neutral who kind of shuttles back and forth between the parties and tries to work out a resolution of some kind. In this case, the time sensitivity was important. We wanted to get Dr. Lankford back to work as quickly as possible. And there wasn't anything in the contract that limited our dispute resolution options to either arbitration or mediation. So we thought that court was the best route here. But sometimes, you can go to mediation or arbitration first.
So David, after 30 days, you and your lawyers felt that you're out of the contract and you said, I'm going to walk out. But you just told me that it's tough to walk out because you're super highly specialized in, you have to deal with PICU or NICU. So did you have something lined up? Like, was there a hospital within the restrictive covenant mileage that you were able to get a contract right away, or what happened?
No, there is another hospital in the network, or in the area that has a pediatric ICU, but they at the time were not hiring. And what ended up happening is I started looking at jobs that were just general peds jobs, outpatient clinic jobs, to do general pediatric because I needed a job. I trained, to do pediatric ICU, but if there isn't one available, I still need to work. So I'm also trained in general pediatrics. So I looked for jobs at clinics, and there are a decent amount around just because Fort Wayne with the outside areas is, it's not New York City. People aren't flocking to come here, so they need doctors. So there were a couple that I interviewed at. And then what ended up happening is in March, one of the pediatric intensive care doctors at the other system had to have surgery and was out for about 10 weeks. So they contacted me and said, hey, you're in the area, we need help because we can't have one doctor covering the pediatric ICU 24/7 for 10 weeks. That's just not realistic or safe. So would you mind coming on as like a kind of a locums temporary fill to help out during that period? In which I said, yeah, absolutely. I get to do what I want in terms of pediatric ICU, help the community that I'm a part of, and keep my skills up, do all those kind of things. So that's what I did, and I worked there for about 6 weeks, and then my old hospital sent what Alex was mentioning before, sent a cease and desist to the new hospital, in which case they said, oh, we don't want to get involved. So
it is literally what got me my next question. My next question was future employers, if you're very transparent with them, which obviously we all advocate transparency, and you tell them this is what's going on, I could imagine that future employers say, you know what, we don't want to deal with this because now we get sued. We have enough legal battles probably on our plate. We don't really need to worry about this. You could imagine that even as you are waiting to resolve the legal issue, it's very difficult to find a job because future employers don't want to deal with this mess.
Yeah, and I don't blame them. It's a big mess, especially when you're talking about a one hospital system and their direct competitor across town, and you don't want to get involved. And so I don't blame them for saying, look, it's not worth the risk. At that point, they only had another 3 weeks they had to wait out. So for them, it's easier and I guess cleaner is a better word to just get locums coverage from somewhere else, cover their way through, and then be done with it. But I talked to Alex a lot about it and say, look, does this make me unhireable? Like I have a recognized doctor that doesn't sue hospitals, but you get to be seen as sort of like a problem child, and people don't want to deal with it, and it makes it really hard to say, look, it was just a one-time thing, but it's on your record. It's tough. It's tough, I think.
Alex, does it make him unhireable? I think personally, if you're an ICU physician, I could totally appreciate the fact that, there's a reason why you did your fellowship and training, and you can always do general stuff for a couple of weeks and be a team player and move on, but you can't do it as a career. Otherwise, why did you do your fellowship? But I can see how this may be very difficult for anybody to find another job.
Sure. Unhireable, no, I don't think so. But I think it's the same issue as when we look at when you're signing up. where it depends. It depends on how badly they need the services. It depends on your negotiating leverage. And if it's something that they can get filled with locums coverage from a doctor that does not have, legal complications coming along with them, I think from an employer standpoint, you're probably going to pick the one that has no legal issues, right? So I don't think it's unhireable. I think that it makes things more difficult, certainly.
So, David, what happened? Now you had to leave after 6 weeks. Where did you go?
So went back home, took care of my kids, and then went back to the trail looking for more jobs. And interviewed at a couple and was considering taking a couple and talked to locums companies, but pediatric ICU, especially coming into the summer, because at this point it was around May-ish. The need is not as high in the summer because, like I said, it's a very seasonal specialty. So, the summer months, you don't have as many intubated kids, you don't have RSV. So in order to get a locums job, I mean, the ones I was looking at that I was talking to were, Montana, South Dakota.
And your wife was still with the same system that you left.
Yeah, she was still working. She was working up in Michigan, Southern Michigan at the time. Mm-hmm. And we were living in Northern Indiana, kind of splitting the difference between Fort Wayne and where she worked. So, I mean, the jobs I was looking at were far, and to the point where I was taking plane rides and being away from my family. But I need to work, so it's a really tough situation to be in for sure. So,
did you find a job?
At the time, no. So what ended up happening is I talked to Alex and Delaney and Delaney and said, like, what can I do? The non-compete, which once again I felt was not enforceable, but it's not, I can't give myself a job, so I have to find a hospital system that agrees with that. The question was, okay, do we take it to court and try and do what Alex was talking about earlier and challenge the cease and desist and get an injunction on that so that I can work? And the decision we came to is that would be the best thing for me and my family, is to try and get at least a preliminary injunction on the cease and desist so that I could work in the area and be with my family and do the job that I wanted. So that was the route that we chose.
How easy or difficult is, Alex, to get the injunction on the cease and desist?
Difficult. So a preliminary injunction proceeding. So when you file for an injunction, you're asking the court to issue an order telling someone not to do something or to do something, either way. I think restraining orders are a species of that, where you're saying, stay this many feet away from this person, right? So in Indiana, the law is more difficult for an employee. There are certain elements that you have to show to the court for the court to grant you a court order that essentially here we were asking the court to issue an order that told Lutheran that they were not allowed to attempt to enforce the non-compete. So no more cease and desists. And it's difficult to show all of those elements from an employee standpoint because the law is, at least in my opinion, not as favorable, whereas it's more favorable to employers. So it's a hard road. It's an accelerated proceeding. So we filed the complaint, which starts the lawsuit. We filed that in July, and then we had a hearing on that with witnesses and evidence in August. Is that right, Dr. Lankford?
August,
early August.
August,
and that's yes, right. So that's really fast for a lawsuit. I mean, generally, before you have an evidentiary hearing on something where you're actually, in a courtroom questioning witnesses, you've got months to years before that happens. So it's a very quick process. So that increases the difficulty, but obviously we were able to get a favorable result here, and we think that result was right. We think the court did the right thing, but it's difficult. It's difficult from an employee's position.
So you had the hearing in August 2023, mm-hmm. And you had witnesses, who would come in? Maybe help me understand who would testify in something like this, and then what was the court's ruling?
You want me to?
Maybe David, at least who
Sure.
testified on your behalf, and then we can go to the court ruling from Alex.
Yeah, so the main people testifying on my behalf was first and foremost myself. So I got up on the stand and was on the stand for about an hour and a half, answering questions both from my attorneys and then from the opposing counsel. And then we had one of the other physicians in the area that I had worked with before, talking about what it means that I'm not practicing, what it does to my skills, what it does to my reputation in the community, especially as an intensivist. If you don't practice those skills and you don't intubate anyone for a year, or you don't put in lines for a year or anything like that, it's not like riding a bike where you just get back on and pedal. It's a very difficult thing to not be able to do for a while. And to be perfectly frank, they're life-saving treatments. If you can't intubate a baby that's in respiratory failure, that is life and death. So it's a massive problem. And then we also had an administrative person from around the area testify about the need for pediatric ICU and pediatric care for the area itself, saying, look, if you have someone on the sidelines who can provide this care, the community is hurting, because it really makes a difference when you don't have the doctor with these skills able to practice. So that's who we had testify on our side, and their side they had administration mostly from the hospital itself, talking about the conference.
How was cross-examination, David? Like, what did they cross you on? Like how did your lawyers prepare you for a cross-examination? Because what I have learned is trials are won on cross-examination. It's never on direct exam, because they're always going to throw you the softballs in direct exam.
Yeah, so it's funny that you say you always want to be a lawyer. I never wanted to be a lawyer. My father is a lawyer and wanted me to be a lawyer, and I never, ever wanted anything to do with it. So for me, going to court was extremely stressful. It's well out of my comfort zone. It's not what I wanted to do. So I was.
I didn't say it wasn't stressful for me. I just said I want.
Yeah. So for me, it was stressful. But we talked beforehand, and we had some depositions. So we had answered questions, and my lawyers. The only. I mean, we talked about what could come up and that kind of thing. But really, the prep was, look, just go up there and just tell the truth. Right. You have the facts on your side. Just tell them what happened, and how you feel and how it affected, and let the facts.
Is this a jury trial?
No, it was just in front of the judge.
Just a judge. So how cross-examination? What did the other lawyers try to do on your cross-examination?
Alex, you want to take that one?
Sure. I mean,
I was just trying to survive.
Yeah,
so.
Yeah. I think the goal on cross is to poke holes, right? So, or to undermine credibility. That's another one. Try to catch somebody in a lie or whatever. For this particular proceeding, because there are these very sort of strict elements that you have to fulfill, I think that the goal on cross was to show the court that some of those elements were not met. So immediate and irreparable harm is one of them. That if the court does not grant this order, you're going to immediately and irreparably be harmed by continued enforcement of the non-compete. So I think that was more the focus, is sort of working through those elements, and then a factual background. So from the hospital's perspective, what was the actual impact on Dr. Lankford's day-to-day activities? What are his medical capabilities? What is he able to do? So I think those were some big areas of focus. It's difficult for sitting from my position, where you work up a case and you are on your client's side all the way through. It's sometimes difficult to predict exactly what the other side is going to try to get, or how they're going to try to use testimony against your client. But I think those were the sort of main points. Like Dr. Lankford said, I think you were on cross for 40 minutes or so. I mean, it was long. They also talked about the job search. So where did you look for jobs? Are there really not jobs available outside of this area that would have worked for you? And again, that goes to that immediate and irreparable. If you can get another job, then how is this going to irreparably harm you? But
Is
yeah,
40
I mean,
minutes, is 40 minutes too long on cross? I think that's
it
short.
depends. It depends on what the case is, right? So, and I know that's the lawyer answer, but it just depends. It depends on the witness and what the
Right.
facts are and how many things you need to hit. I think for this proceeding, that your testimony was the longest, to my memory, which is common. You know, the person who's bringing the claim is going to talk longer. But just from a sort of endurance standpoint, it's difficult, and clients always struggle. You know, the other sort of testifying that clients generally do is a deposition. So that's outside of court, but is essentially an interview with a court reporter in the room. So the other lawyer gets to ask questions, and the court reporter writes down the questions and the answers. So that's an evidence gathering tool, but those can be up to 8 hours. So those are very difficult, and those are kind of a long haul. But being in the courtroom, I think, is a more stressful experience.
So then this is a judge decision. There's no jury. There's no deliberation. Does the judge say, I'm gonna take a couple of days and think about everything, or does he make a decision right away? Like, I mean, how does that work? So you finished both sides, right? What happens?
Yeah. So, and I'm sorry, Dr. Lankford, I don't mean to step on you. I think this.
No, you're fine.
So here, we had originally asked for what's called a preliminary injunction. So that's generally an order that is a preliminary ruling from the court that they say you can't do this until we figure out the case. So it's to maintain the status quo. There's another procedure that you can use that's called a temporary restraining order. So temporary restraining order is shorter in duration, and from cases that I've studied, they generally come before. So you would get a temporary restraining order first, and then have a hearing on a preliminary injunction. So temporary restraining order is, if a preliminary injunction is fast, then a TRO is very fast. So at the end of the hearing, we asked the court to enter a temporary restraining order while it considered our request for a preliminary injunction. The court, I think our hearing was on a Friday. The court asked the lawyers to submit written arguments on the temporary restraining order the following Monday. And then the court issued the temporary restraining order in our favor the next day. So that was very fast, and that allowed Dr. Lankford to get back to work that week. And then the common phrase is the court will take it under advisement. So basically what that means is the court will think about it, look over your papers, and then issue a decision. And the preliminary injunction ruling was, I don't remember how long after that, but we submitted some more, written arguments, and then the court made its decision.
But where did you return to work? I mean, at the time you did not have a job, no?
Yeah, so I once the temporary restraining order was granted, then the other hospital in town was comfortable with it because now a court has said that I can work. So I went back to work as basically as an independent contractor because they didn't want to do like a full long-term contract, not knowing with the preliminary injunction still out there and it being just preliminary. So they hired me as basically locums or independent contractor. And then I started working for them right away. Like literally, I think the next Monday I started taking shifts. So, and then I'm still doing that now that, we're kind of waiting on other things, but.
So where do things stand right now? Like, where do things stand right now? Because you're working, you have the temporary injunction. Is the legal battle still ongoing?
Yeah. So yeah, the temporary restraining order got me until the injunction ruling, and then the judge ruled in our favor on the preliminary injunction. So I have the preliminary injunction, which is, Alex can correct me if I'm wrong, but kind of indefinite right now. And so I'm working under that. And then the next step will be the restraining order, or the non-compete was a year long. So January 7th, that year expires. So then the question is, okay, after that year, now will the new hospital say, okay, even if they could enforce it, the time period is over. So now you can work full time. But in the meantime, the injunction is still just preliminary. It's not a final ruling. So it's still kind of up in the air for that.
Right. And then I guess just one other facet here, Lutheran has countersued Dr. Lankford. So they have sued Dr. Lankford for breach of contract, and they're alleging a few other claims. And they've also sued the hospital that Dr. Lankford is working at now. So those claims are ongoing. So we're defending those claims And also Lutheran has asked the court to dissolve the preliminary injunction, basically to take it away, which is something that they're allowed to do under the rules. So that's what we're working on now, is responding to their request to dissolve the preliminary injunction and their claims against Dr. Lankford.
So a couple of questions in the remaining 10, 12 minutes. One, is there any chance that the federal government comes out and says, these non-competes make no sense, it's a law that nobody should have a non-compete in their contract, and resolve these issues? I don't want to get Alex out of a job, but I really feel that, I mean, there's so much energy, just listening to the energy that has been spent. Even the hospital now, they are suing you and they're countersuing. I mean, it just seems there's so much emotion that gets involved into this, where occasionally when emotion interferes with decision-making, logic goes away. So is this ever on the table that the federal government might say, forget all of this stuff, or am I dreaming?
Yeah, no, the FCC has a proposed rule now that would ban non-competes nationwide.
Where's that going to go?
So I have no idea. That's a great question. I don't know. The industry lobby is very strong. So employers say we invest significant resources into our employees, and this is across industries. Their argument is we invest significant resources, we train these people, we give them the tools to succeed, and then they take all of that information and knowledge to our competitor and use it against us. I mean, that's essentially the argument in favor of non-compete agreements. So the proposed rulemaking process is not my area of expertise, and it's complicated, but my elementary understanding is the FCC has issued a proposed rule, and then there's this period of time where anyone who's interested can comment on that and send the FCC their thoughts, and then the FCC incorporates those suggestions into the proposed rule, and then there's some sort of final rule. But I don't know. I don't know how that's going to turn out.
I can see the argument of investing in you, right? I mean, if I'm joining a practice, I have no patients. There's a lot of investment. They give me space, computer, maybe marketing, assistance, give me some patients. I get that. But I think after a certain time, obviously, like, I'm on my feet. I'm getting my own referrals because I'm a good doctor. I'm communicating better. I mean, I wish there was a time you say, okay, if you leave us in the first 3 years, we invest a lot of time, then we enforce. But after 3 years, clearly, it's no longer the practice that is really investing in you. It's really, at this point, you have really invested in yourself and your own growth. But that's logic, and logic does not enter the equation here.
Yeah, that's a difficulty with how contracts work, that these provisions don't kick in until you leave, right? So, yeah. I mean, I regularly have physicians with 10, 15-year-old contracts that are leaving, but their non-compete's going to kick in as soon as they leave. Yeah.
So weird.
Yeah.
David, why not pack up and just go to Michigan? I mean, just go 30, 50 miles away, go to Indianapolis, come to Chicago. I mean, why do you want to go? Again, I mean, I'm sure that you are paying a lot of money for legal representation because the way it is. But why? We commend you for fighting the battle. I mean, clearly, despite the fact I'm moderating this, but I'm clearly on your side here. But pack up the bags and go somewhere and put this behind you and start fresh.
We thought about it. I talked to my wife a lot about it. She's a general surgeon, so her skills are very much in demand. So her getting another job, probably not that hard, especially because she's exceptionally good at her job, so that doesn't hurt. But the fact of the matter is, like, this is where I live. This is my house. We built a house here. My kids are in school here. We like the community. My family is close. They're still in Detroit. My sister's in Chicago. My in-laws all live in Fort Wayne. My brother is an oncologist here. My sister-in-law is an NP here. We just have everything here. And I don't mean to be blunt, but I don't feel like I should be forced to move and be pushed out of my home because they made decisions that I personally don't think were right. So we talked about moving. We talked about going back to Detroit, where we did training and have some roots there. But it just, I I just feel like I don't want to get pushed out of where I love because they made decisions that I don't agree with. So
Alex, had David decided not to work for a year, took a year sabbatical, right? Because the non-compete was 1 year. So he just took a long vacation for a year and did whatever he wanted to do. Would this thing would have been over? Because it's only 1 year, right?
I mean, under the contract, yes, the non-compete would expire. I think our argument and what we believe here is that would have harmed his career significantly and irreparably. I mean, he spent 5 years
Because
in
of the
community
PICU,
building a
because
referral
it's
base.
intensivist, yeah.
And right, because the skills deteriorate. So yes, I think that's sort of always one of the options is you can sit on your hands for a year and then go back to work. But I think for a lot of reasons, that's not an option for a lot of people. You lose your referral base, your skills deteriorate in that period of time. And we had testimony at the hearing that Fort Wayne and Allen County is a community that needs the services that he's providing. So it's not just Dr. Lankford, it's also critically ill children in Fort Wayne and Allen County. So I think that is, in my opinion, outside of my job as a lawyer, I think that is one of the worst parts of physician non-competes is you have qualified doctors who could provide care sitting at home not doing that because of a contract provision.
Yeah. I learned about this story through an article that was written in NPR WFYI Indianapolis. It's a PBS outlet. And obviously, I wanted to highlight this topic because I think it's also important. Have you tried to leverage media, additional outlets to put some pressure? Because in the article I read, it seems like the Lutheran system refused to respond to the reporter who was writing the article. In transparency, I did not attempt to reach out to them. I didn't think they will talk to me anyway. But I mean, sometimes this public pressure could work. I don't know. I mean, have you tried that?
I don't think we've tried to do it like to pressure them by any stretch. But if somebody asks to talk about it, I like talking about it. I think it's like you said, it's an important issue. I think it affects a lot of doctors. Both new coming out of residency and fellowship, but also like Alex was saying, doctors that have worked 10, 15 years that, are just trying to stay in the community. I mean, personally, there are a lot of small hospitals that I think should be against non-competes because in order to get a subspecialist, so like, let's say you need an oncologist, it's hard to get an oncologist to come to a small community, but if there's one that's working in a big academic center 20 minutes away who wants to get out of academic and just do community oncology, he can't do that, So if you're a small hospital, if he doesn't have a non-compete and he wants to do that, you could get him and you don't have to try and get somebody to move their whole family and everything. So I think it's an important issue that I think should be talked about more. I'm a little bit surprised it's not, but I appreciate you taking the time to do it because I think it's very, very important. So, yeah.
I think a lot of physicians feel they're the underdogs, frankly. It's not easy to fight a healthcare system. I mean, you have to remember, I mean, unless most of these healthcare systems, the lawyers are employed and they actually have a salary, generous salary, but they're salaried. So there's no incremental cost sometimes by filing a lawsuit or something. I mean, I presume. David, maybe with you or Alex, is there anything I should have asked you and I completely did not ask you? Anything that you want to say? Or, I mean, these are the things I had in mind. I'd like to hopefully, I don't know, bring you back in 6-7 months. Maybe there's more information and hopefully all in your favor. But anything else I should have asked that I totally overlooked?
I can't think of anything. Alex, you got anything?
I think the only thing I would add is for any of your listeners that may be, approaching that decision for the first time, where they're leaving fellowship or they're coming out of residency and they're ready to start thinking about this. I know there is expense associated, but it's my opinion that it's always helpful if you're signing a contract, particularly one that you're going to be dealing with over the course of potentially 5-10 years. Have a conversation with a lawyer. It's worthwhile. Even if you're not going to be able to successfully negotiate better terms, at least you'll have a really solid understanding of what the terms in your contract are. And I do talk to a lot of people who are kind of surprised after the fact about the way their contract works. So I mean, I think it's worthwhile, even if it's just an hour consultation with someone
Right.
to talk through what your contract says. I would always recommend that. Divorcing as much as I can from, my interest obviously would be for people to want to do that with me. But I think just in general, it's a value add.
Well, I really appreciate you taking time of your schedule. I know it's an important topic. It's sometimes not easy to talk about, but I suspect that listeners have a better view into what's going on. Who knows? As you mentioned, Alex, there's something in front of the FCC in terms of getting rid of this. I did read something about this probably 6 months ago, and I don't know where that is right now. But Dr. David Lankford and counsel Alex Pantos, thank you so much for coming on Healthcare Unfiltered.
Yep, thanks for having us. Appreciate it.
Thank you.